Welcome to this episode of Called to Account. Today, my colleague Paul Croft and I will discuss the recent judgment in the famous Dick Smith litigation. In brief, the dividend case focused on whether the directors' actions in approving and paying the 2015 financial year interim and final dividends resulted in a breach of the third clause of Section 254T of the Corporations Act, which states that a dividend cannot be paid if it materially prejudices the interests of creditors. So, Paul, it seems to me that the judgment in the dividend case has ramifications for directors beyond just interpreting Section 254T. What are your initial thoughts about the judgment?
Thanks, Jackie, and I think you're spot on. This case is significant because going into it, there was no precedent interpreting the concept of material prejudice in the context of Section 254T. From a forensic accounting perspective, the judgment establishes a framework for evaluating the impact of paying dividend on a creditor's interests, and it makes clear that where there is a breach of Section 254T, the measure of damages is the economic harm to the company, not the quantum of the dividend. And as to the point you make, Jackie, the judgment has some clear ramifications for directors, particularly CFOs, because one, it explains how directors' obligations to creditors under Section 254T operate in conjunction with their duties to the company under Section 180 and Section 588G of the Corporations Act. And two, it elaborates on the nature and the extent of the information directors may rely on when taking decisions about dividends to avoid or mitigate a breach of their obligations under Section 180 and 254T.
So back to your first comment, what are the key findings regarding the court's conclusions about Section 254T?
Look, ultimately the court concluded that no breach of Section 254T arose because the dividend payment either had no impact on creditors or did not materially worsen the position of the creditors through delayed payment. My three takeaways are these. Number one, the creditors relevant to Section 254T are those creditors existing or like to exist at the time of paying the dividend. This is because future creditors, those creditors who don't exist at the time of paying the dividends, are already protected by the insolvent trading provisions contained in Section 588G. Secondly, the court looked at whether the dividend actually caused the company to have a reduced ability to pay its creditors. Now, it said that reduced ability includes not only a material risk that creditors will not be paid at all, but that also material delay may occur in paying them when those debts fall due. And it said that this requires an assessment of and a comparison between the position prior to paying the dividend and after paying the dividend to determine whether creditors are in a worse position. And thirdly, during the course of our expert reports, there was debate between the experts about what due and payable meant. We put forward the argument that it was business practice that companies would defer some payments, and evidence was presented in court that showed that some 32% of business payments were made beyond the standard 30-day term. So therefore, the court concluded for a breach of Section 254T to occur, the dividend payment must make the position of the deferred creditors materially worse, both in terms of the quantum and the period of delay. And when you're assessing that position, the extent to which deferrals were made with the creditor's acquiescence is quite important and may be taken into account.